It's a pleasure to welcome such a great audience of alums, family, friends, students, faculty, interested members of the community, lawyers, doctors, whoever, to this evening's annual Robert H. Kirschner Human Rights Memorial Lecture. We owe a tremendous debt of gratitude to the Kirschner family, not only for the wonderful legacy of Bob Kirschner as a pioneering forensic pathologist who understood the need of the contributions of different disciplines and professions to the diagnosis and solution of human rights problems. The Kirschner family has helped us maintain this lecture series over the past decade, and I'm pleased to say that two prior Kirschner lecturers, Sarah Paretsky, who was the very first Kirschner lecturer, and Alex Kotlowitz, are with us tonight. Before going any further, I'd like to thank our co-sponsors of this event, the Institute of Politics, the International House Global Voices Program, and Alumni Relations and Development, who bring us every year Alumni Weekend. We like to say that the Kirschner Lecture is always Era of Alumni Weekend. The Alumni Weekend starts officially tonight and then proceeds over the next 3 days. One of our students will be introducing David Cole, but David asked me to ask a question of the audience so he'll know who he's talking to. So I'd like, before I go any further, a show of hands. How many people here are students at the University of Chicago? Right. How many people here are alumni of the University of Chicago? Oh, pretty equal. How many people here are faculty or staff of the University of Chicago? And how many people are visitors from the greater Chicago area and further? All right, so we have a pretty good distribution of folks here. I wanted to thank also our staff who really do a remarkable job of making this logistically complicated event look so easy and flawless, because we know that sort of work is always invisible when it works well. If something were to go wrong, you would notice who was doing it. But I want to bring your attention to our staff, Tara Peters, Kira Dalt, Kathy Scott, all our student staff who are here, and thank them for their hard work, which did the publicity, which got you all here, which in cooperation with the staff of iHouse and the Institute of Politics has made all of this possible. So I want to shout out to the staff. I also want to thank Ann and Richard Posen and the other donors to our program who are listed in the inside back cover under support. Many of you are here tonight, and we really appreciate your support, which particularly is dedicated to keeping our internship program going. This year we will be sending a full complement of students out to do human rights work in the United States and across the world. There will be 30 students who are getting grants of $5,000 apiece, and it's thanks to the generous contributions not only from our endowment from the Posen family, but from donors like you. We need this money every year to make sure these students have the transformative experiences that those internships are. I would also like to draw your attention to the pages of the program, starting from the center spread and into the next couple of pages, which really documents a lot of what we do in the Posen Center, which is support outstanding work in human rights, scholarship, and practice among our students. We have the winners of the Ignacio Martin Barro Human Rights Essay Prizes. Those essays are available to read on our website. We have the winners of the research grants for PhD students. We have the winners of the graduate lectureships in human rights, which is actually a fund from the college that allows us to have PhD students invent and teach human rights courses of their own creation. We got a really interesting range of topics. We have a Posen Human Rights Dissertation Completion Fellowship, which provides a year of support to an advanced PhD student who's at the phase of writing their dissertation. And finally, we have the Isaac Wolf Post-Baccalaureate Fellowship in Human Rights, which is a one-year fellowship for a college graduate who wants a year of practical experience at a human rights organization. Now, I initially thought this would be a launching pad for a career in the NGO world, but it has turned out that almost all of the recipients of this grant have gone on to PhD programs, which I think will make them better and more engaged professors and faculty members when they get into academia. It's really a pleasure to welcome also the members of my college class, the class of '72. We are celebrating our 45th reunion this year, and I have a special welcome for all my friends who are in the front rows. And I also wanted to make sure that you all realize that after this session, there will be a really nice reception in the lobby and courtyard of iHouse, again supported by the Kirschner family, because we know that besides for being serious about human rights, forensic pathology, torture, and other things, Bob Kirschner also loved good food. And the family has continuously made sure we have, what would we call it, a lavish reception that goes beyond the usual chunks of cheese. So you're all reminded that you should stick around afterwards. It's a pleasure to welcome David Cole to Chicago. One of our students is going to introduce him, but I want to mention that I met David 30 years ago working on a then infamous deportation case in Los Angeles known as the Los Angeles 8. Many of the issues that were involved in that case are still with us, questions of free speech, questions of the rights of non-citizens, and it has really been up to many of you who have participated in and contributed in efforts to defend the rights of all people in the U.S. to keep us going even when it looks very dark. So I'm now going to introduce Dana Al-Masri, who is a fourth year in the college and who will be introducing David Cole. Dana is both typical and exemplary of college students. She is a major in fundamentals in the New Collegiate Division. She also started a creative writing group. She did a human rights internship last summer in London at an asylum advocacy organization. And she is now, after graduation, going off to a very interesting fellowship to intensify and raise the level of her Arabic. She will be studying in Cairo next year. She's also spent this past year with 3 other students as the mentors for the 2017 crop of human rights interns. We always pick 4 students from the year before, and they have done great work helping this new wave of students prepare for their summer experience. So, Dana?
Never blushed so much in front of so many people. Good evening, ladies and gentlemen, and thank you for coming inside on such a glorious day. My name is Dana Al-Masri, as Susan so kindly mentioned, and I'm a fourth year in the college, and I have the privilege of introducing the 2017 Kirschner Lecture speaker. Mr. David Cole is the National Legal Director of the ACLU and the Honorable George J. Mitchell Professor in Law and Public Policy at the Georgetown University Law Center. He's the author of several books, including Engines of Liberty, The Power of Citizen Activists to Make Constitutional Law, and is a successful litigator whose victories include major constitutional cases in the Supreme Court, as well as important cases that challenge restrictions on federal funding for AIDS education, obtained injunctions against those who block access to abortion providers, and fought, as Susan mentioned, deportation proceedings against Palestinian immigrants targeted for their political affiliations. Mr. Cole sets a high standard for somebody like me. As Susan already mentioned, next week I will graduate from the college and I hope to attend law school after this year in Cairo. As a working lawyer and public intellectual, Mr. Cole's impact on the lived reality of abstract and aspirational values like freedom, like democracy, like respect and security is not limited to the courtroom or the book stacks of the reg. His regular contributions to publications like the New York Review of Books advocate for the protections of civil liberties, for the protections of human rights, and situate them within domestic, political, and social concerns. By engaging the public forum, his work defends such values against deliberate attacks and the steady erosion of disengaged citizenship. As a woman, as an American, as a daughter and granddaughter of immigrants, as a Syrian, an Egyptian, a Brit, and a Muslim, it's a lot, I would personally like to thank Mr. Cole, on behalf of myself, Party of One, for engaging in this necessary work volubly and without hesitation. Please join me in welcoming Mr. David Cole.
Thank you. Thank you for that beautiful introduction. I really, really appreciate it. It's lovely to be here. It's always good to be back in Chicago. I grew up in Evanston. My mom is from the South Side. I've spoken here at the International House in the past, and it's nice to see friends here once again. I'm going to talk about, a specific human rights organization, the ACLU, and our specific challenge at this particular moment in this country, which is to defend liberty in the age of Donald Trump. But it's really as an example of a broader point that I am speaking about the ACLU. And that point is the necessary interconnection between the formal institutions of government which create the possibilities for checking abuse of power and the critical role of citizens and informal institutions in giving those formal institutions the true checking power that they have potentially. So what I want to talk about is sort of how the particular moment, and namely the election of Donald Trump, has changed things for us at the ACLU, for us in the United States, for us in the world, in light of today's announcement, and talk about the ways in which the threats that the current president and his administration pose create real opportunities going forward if we take them. So I really, just began this job at the ACLU in January. January 9th was my first day on the job. January 11th, I testified on the nomination of Jeff Sessions. So I didn't have a lot of time to rearrange the pictures in my office. But I took the job last summer. I was recruited to take the job by the ACLU's executive director, a man named Anthony Romero, who came to me with an offer that I couldn't refuse. He said, look, David, you have been a constitutional lawyer for 30-some years, advocating for constitutional rights under a conservative Supreme Court. Just imagine what you could do leading the ACLU, and particularly its Supreme Court work, under a liberal Supreme Court. And this was the summer, remember? It's hard to think back to that time. But that sounded like a pretty good deal to me, because I went to law school in the 1980s, and I was taught by professors whose view of the law, and particularly of constitutional law, had been shaped by the Warren Court, Brown versus the Board of Education, the Civil Rights era. So they had this very glorious view of what the Supreme Court could do in terms of constitutional change, and that's what they taught me. And then they threw me out to practice constitutional law under the Berger Court, the Rehnquist Court, the Roberts Court, et cetera. So the idea of practicing under a liberal court, and in particular being the voice of the ACLU in that court, was fantastic. I didn't put in any little condition saying, what if? Because that was so not even thinkable, the what if. Well, the job changed on November 8th. And in some sense, the ACLU changed on November 8th. So the work that we are undertaking now has moved from offense to defense, from the possibility of an inside game to advocate and press for civil liberties to the necessity of an outside game, from being criticized for suing a Democratic administration, as we were under President Obama, to being celebrated for suing a Republican administration. We are, at this moment, a bigger, stronger, more resourced organization than we were on November 8th. We have more members. Our members are younger. We have more engaged members than ever before. I like to tell people, you know, before I started working for the ACLU in January, we had 425,000 members. Today, we have 1.6 million members. Now, there's a, yeah, that's worth it. There's a difference that you learn probably on the first day of, you know, University of Chicago between correlation and causation. That proves it right there. I don't think I can take any credit for a single member. Maybe my dad. I think my dad joined. But otherwise, I think we have to give the credit to that guy in the White House. And it is a little odd to be at the ACLU at a time when it has such support. I was here a couple of months ago and speaking to a longtime ACLU of Illinois a person who was saying, you know, it's not really fair that I started working for the ACLU in January when it's popular to be a member of the ACLU. You know, you should know what it's like to be working for the ACLU when it's unpopular. And no one knows that better than the affiliate here, which of course defended the Nazis' right to march in Skokie. But we have become, you know, very, very popular. So we have Tom Hanks and Tina Fey and Usher doing Facebook Live fundraising events for us. We have massive concerts in LA with all kinds of totally hip groups, none of which I've heard of. That proves how hip they are to raise money for us. We have kids in junior high school doing bake sales and sending us the proceeds. We had, there was a couple of months ago, a across the country organized night where Irish musicians went to Irish pubs. Of course, I don't think that really distinguishes it from any other night, but they went to Irish pubs and did what they do, drank and played music, and raised money for the ACLU. It's just, we had at the Academy Awards, people wearing ACLU ribbons. We didn't even have ACLU ribbons until the Academy Awards, but now everyone wants to wear them. My favorite is that Vogue magazine in the current issue has a feature on women of the ACLU. But I feel like we really arrived when the week after we got the first injunction barring the Trump travel ban. We got the Trump travel ban was put into place. The first iteration was put into place on Friday, January 27th, 7 days into his term. On Saturday, January 28th, we got the first injunction and joining its application in a case in Brooklyn. And that week, that following week, the New York Times crossword puzzle had a clue. The clue was, group that told Trump, we'll see you in court. And the answer was ACLU. So you know that's when you've arrived, when you are the answer to a clue in the New York Times. So in many respects, it feels quite different at the ACLU. But in a more fundamental sense, I think things are, we haven't changed. It's that circumstances have changed. So we are doing what we have always done from our founding in 1920 to today. We defend the Bill of Rights. We stand up for principles of equality, liberty, dignity, and privacy, for the rights of the vulnerable, the disadvantaged, and the despised. We stand for the basic principles of the Constitution's Bill of Rights and of human rights more generally. And we've always done that from our founding in 1920. 1920, when we sought to defend the rights of workers to be protected from employers that were exploiting them, to the 1960s, when we defended civil rights activists, to the 1970s and 1980s, when Ruth Bader Ginsburg, then an attorney with the ACLU, helped shape the Supreme Court's recognition of sex discrimination, to 1990, when we were instrumental in drafting and getting enacted the Americans with Disability Act, to the victory in 2015 on marriage equality. We've sued Republicans and Democrats alike when they have violated human rights. And so we're continuing to do the same thing we've always done. It's just that circumstances have changed and people are more concerned about these very rights and more understanding of the critical need of organizations, institutions, civil society organizations committed to the defense of those rights. So in normal times, I think many of us can take for granted the existence of the basic rights reflected in the Bill of Rights and reflected in the Universal Declaration of Human Rights. In this country, we have a fairly robust tradition of the protection of rights. We have fairly robust institutions that are designed to protect those rights. We have a strong civil society, and so many of us can sort of be, well, here I am at the University of Chicago, be free riders, right? But in a time like now, when a president like President Trump has been elected, that luxury is no longer there. That luxury is no longer there, and the engagement that we are seeing, not just at the ACLU, of course, but in the streets more generally, in the town halls on the ACA, in marches and across the country on any number of issues, it reflects this sense that there is a real threat to basic human rights, and so it is important that we stand up, engage with those institutions that do that work, and fight back. And in a way, I think that's the way it ought to work. It's sort of a market response. Again, here I am at University of Chicago, a market response to human rights. When human rights are doing okay, relatively speaking, well, then the institutions that exist, like the ACLU or Human Rights Watch or the Center for Constitutional Rights, we continue to do our work, but we have a certain level of support. When the need for these sorts of organizations is great, people respond. People come together, people sign up, and those organizations are much stronger for it. So, and never is that kind of, this kind of checking institution more important than when one party controls all three branches of government, of the federal government, and many of the legislatures in the states as well. Susan mentioned my book, or Donna mentioned it, my book, Engines of Liberty, which I wrote last year, that talks about the role of citizens in defending liberty and advancing constitutional rights. And in the course of writing that book, I examined some successful human rights or constitutional rights campaigns and asked, how do we understand the successes? How do we understand that marriage equality went from unthinkable to inevitable over the course of 35 or 40 years? How did the individual right to bear arms which was dismissed as a fraud in 1990 by Chief Justice Warren Burger, a conservative Republican-appointed Supreme Court justice. He called it a fraud, the notion that there was an individual. How did that become a constitutional right 18 years later in the Supreme Court in the case of District of Columbia versus Heller? And what caused President George Bush, by the time he had left office, to have curtailed all of the most aggressive anti-terrorism measures that he had put in place in the wake of the terrorist attacks of 9/11? And the answer in all three cases is not lawyers making clever arguments in court. It is citizens, lawyers and non-lawyers, coming together in civil society institutions that are focused on defending and advancing particular visions of human rights and constitutional law. And in the course of that book, I talked to virtually everybody, who is anybody in the NRA. And one of the questions I asked to a former president of the NRA was, why is it that your membership is reputedly so much more engaged, so much more responsive than the membership of so many other nonprofit organizations? And this is, many people have looked at this and have found that NRA members respond when their organization calls much more reliably and readily and energetically than members of most other advocacy organizations. And he said to me, he said, well, I think the key is that you have to have the threat. And the threat for the NRA is the threat that liberals are going to take away their guns. And liberals are dismissive of that threat, but precisely because liberals are dismissive of that threat, gun owners feel that it's probably, it's a legitimate threat. And that threat causes NRA members to join, to support the NRA, to respond when it asks them to call their member of Congress, to go to their state legislature when it asks them to do that, to vote for the candidate who they endorse because of his or her position on gun rights and the like. And that is really the source of their power. Well, we, in the community of human rights and in the community of civil libertarians, now have the threat, right? The threat is Donald Trump. And the threat of Donald Trump to the rule of law, to basic civil liberties, to the very concept of judicial review is a threat which creates the opportunity for mobilization like I have never seen. I've been, as I say, a constitutional lawyer for 30-some years. I have never seen citizen engagement around civil liberties and constitutional rights like we are seeing today. And at the end of the day, that will be our salvation. So what is the threat that Trump poses? How are we responding to it? And why do I think we can prevail? So the threat, probably in this room, I don't need to go into it in great detail, but this is a president who, shortly after his election, tweeted when some students burned a flag at some college somewhere in protest of Donald Trump's election, he tweeted that these flag burners should be jailed and have their citizenship stripped, which was kind of a remarkable feat because that meant in a 140-character tweet, he proposed 2 unconstitutional acts. It is a constitutional right to burn a flag, a case that I had the fortune of handling in the Supreme Court with Bill Kunstler on behalf of Joey Johnson in a case called Texas versus Johnson. Joey Johnson is here tonight. And it is a constitutional principle going back about 50 years that the government cannot strip your citizenship no matter what you do. Even if you commit treason, you cannot have your citizenship taken away from you. It is a constitutional right. It can't be taken away from you. Yet Donald Trump, in a 6 a.m. tweet, proposed doing both of those things. He wants to loosen up libel laws. He promised to ban Muslims. He promised to overturn Roe versus Wade. He wants to revive stop and frisk policing. He was in support of torture. And he has more generally, I think, been just shown a kind of dismissive attitude towards the very foundation of both human rights and civil liberties, which is the notion of checks and balances and the appropriate role that other institutions of government have in checking the power of the president. So when the courts declared his first travel ban unconstitutional, he referred to the judge as a so-called judge. His attorney general, Jeff Sessions, when the Hawaii court declared his second version of the travel ban unconstitutional, Jeff Sessions pronounced wonderment that a judge in an island in the Pacific could enjoin the president. Well, that's actually called judicial review. That is the foundation of the protection of constitutional and human rights in our country. So Trump poses tremendous threats. And what does that mean for the work that we're engaged in on an everyday basis? It means that we are focused in the courts on those measures that he has put in place, and we are focused in the broader arena of public opinion and advocacy on the proposals that he wants to put in place but has not yet been able to because of a combination of Democratic opposition and his own office's scandals and incompetencies. So that includes on immigration, the challenge to the travel ban, which I'll come back to in a moment, but we have about 15 cases filed challenging the travel ban on behalf of various individuals around the country who were caught up in that ban. It includes challenges to measures that he has announced in executive orders that will be put in place in order to ramp up deportation. And he has promised to dramatically increase the rate of deportations in this country. President Obama already had ramped up deportations to historic highs. So ramping it up even higher is going to take some doing. And how do you do that? Well, one way you do that is by denying people procedural protections, because procedural protections get in the way of deportations. And so they've proposed expanding something called expedited removal to deny people who are picked up in the United States an opportunity to have a hearing at which they can defend themselves before they are removed. They are simply removed without a hearing. They are engaging in much more aggressive ICE raids, because if you're going to ramp up deportation, you've got to pick up more people. And so we have reports of ICE hanging out outside of courthouses and arresting people who show up in court to be a witness or a juror or a victim of a crime and putting them into deportation proceedings. We will see and already are seeing increased detentions of immigrants to again ensure that we can deport them quickly. We have a constitutional challenge to the limits on immigration detention pending in the Supreme Court. And we are supporting those cities that have chosen, as is their constitutional right, not to enforce immigration law with their own state and city police forces. And many cities have chosen this because it undermines your ability to keep the city safe and to do the ordinary policing work if people fear that if they come forward as a witness or a victim to the police, They will be asked what their immigration status is, and if their immigration status is out of status, they will be on a plane going home, or members of their family will be on a plane going home. And so many cities have said, you, federal government, can enforce immigration law, but we are not going to enforce the immigration law. And that, under the 10th Amendment to the Constitution, that is their right. Donald Trump doesn't like that. Jeff Sessions doesn't like that. And so they've threatened to pull back all federal funding from cities and states and jurisdictions that decline to choose to enforce federal immigration law. In a case out in California, a federal judge has declared that initiative unconstitutional, as well as interfering with states' rights. On reproductive freedom, we have seen an increase in efforts to shut down abortion clinics by imposing new and more restrictive conditions on their operation, inspired by Donald Trump's promise to seek to overturn Roe versus Wade. And the federal government itself has proposed an expansion, a revival and expansion of something called the Global Gag Rule, which says that we're going to use the carrot of federal funding to silence people from speaking about abortion. So as set forth by the Trump administration, if you're a foreign organization anywhere in the world and you want to be eligible for any kind of federal health funding, whether it be Zika or malaria or AIDS prevention or just basic health care funding from the federal government, you have to agree not to talk about abortion at all, not to promote abortion at all, not to provide information about abortion, even with your own money on your own time. So they are using the billions and billions of dollars of federal aid to skew the marketplace globally on the right of abortion. Here in the United States, they leaked yesterday was what they call an interim final rule, which sounds like a oxymoron, but it is a thing that goes into effect immediately and would provide that any employer who objects to providing contraception to its employees on religious grounds need not provide contraception through their employer insurance to their employees. In other words, women would be denied access to contraception because of to pay essentially for the religious beliefs of their employers. And we stand ready to challenge that as well. On voting rights, President Trump has personally attested to knowing that 3 to 5 million people voted fraudulently. He hasn't yet been able to identify any one of those 3 to 5 million people, so he has now created a federal commission to go out and find those people. And it's headed up by a guy named Chris Kobach from Kansas, who is one of the key architects of both anti-immigrant measures and voter suppression measures. And voter fraud is, as probably many people know, voter fraud is actually not something that happens very often. It's entirely irrational to engage in voter fraud because you face potential criminal sanctions if you vote fraudulently, and the likelihood that you actually might change the result by voting is zero. And so it doesn't happen. But it's a fantastic fiction, because if we identify it as a problem, then we can create all sorts of restrictive rules that are ostensibly designed to respond to the concern about voter fraud, but are actually designed to suppress the votes of people who are unlikely to vote for the Republican Party. And we saw this in North Carolina in a case that we brought at the ACLU, where the North Carolina legislature enacted a series of measures designed to suppress the votes of black people. How did we know that they were designed to suppress the votes of black people? Because the North Carolina legislature only adopted them after asking for data on which measures black people used more than white people. And then those were the measures that they singled out to curtail. Why did they do that? Well, one expert in the case testified that in North Carolina, being African American is a better predictor that you will vote Democrat than if you're a Democrat. So it's a very useful and tempting proxy. The Fourth Circuit in that North Carolina case declared the measure unconstitutional as race discrimination, and just 2 weeks ago the Supreme Court agreed not to hear the North Carolina appeal. So these are just some of the areas in which we are working. There are many more, and I'd be happy to talk about them in the Q&A. But the question that many people ask me is, well, why do you think you can prevail? Given that the Republicans control the president, the Senate, the House, Republican majority on the Supreme Court, given that they have control of 2/3 or so of the state legislatures, where are you going to find the checks in this system to stop the president? My answer is the people. That in a democracy, if the people are against you, if the people oppose what you're trying to do, you will have a very hard time actually putting those measures into place. And that's, I think, what we are seeing, from the Women's March to the Tax Day March to the March for Science to the people who showed up at town halls, to the people, the million-plus new people who have come on to join the ACLU. These are people standing up to stand in the way of the rights abusive measures that this administration is proposing. So, but still, how's it going to happen? Where's the check going to come from? And I say, well, you know, sometimes it feels like there is no place for it to come from. But I think if you look back at history, you'll see that, in fact, checks can arise and can operate even when the president has tremendous advantages on his side. So think back to immediately after 9/11. President Bush, in the wake of 9/11, had essentially all the advantages that Donald Trump has, plus some. He had a Republican Congress for most of his 2 terms in office. The Supreme Court was the Supreme Court that put him in office in the first place by stopping the vote in Bush versus Gore. He had history on his side, because history had shown that Congress and the courts, and indeed the American people, defer to the president on matters of national security in times of crisis. And after 9/11, he had approval ratings as high as 90%. Hard to imagine at this point, but that was, in fact, the case. And he acted in the immediate aftermath of 9/11 as if no one could check him and no one would check him. But as I indicated before, by the time he had left office, he had curtailed all of the most aggressive anti-terrorism measures that he had put in place. So by the time he had left office, the Supreme Court had ruled against him 4 times on cases pitting the rights of so-called enemy combatants against the security prerogatives of the president. By the time he'd left office, he had released over 500 of the people at Guantanamo. By the time he'd left office, he had closed the CIA's black sites. He had suspended the CIA's torture interrogation program. He had ended the CIA's extraordinary rendition program in which it picked people up in country A and delivered them to country B so country B could torture them for us. And his warrantless wiretapping program was now under judicial supervision and legislative constraint. So how did that happen? Well, if you read George Bush's memoir, and I'm not recommending it, but if you read George Bush's memoir, I did for my book, you find that it wasn't that he had some change of heart and decided actually these things are not necessary. He doesn't think he made a mistake at any point during his administration. What made that happen, what caused him to curtail, was the work of civil society organizations, citizens coming together around basic commitments to human rights and engaging in a variety of tactics to defend those human rights and to put pressure on the administration so that the voices within the administration who supported a more restrained approach ultimately gained sufficient support to bring some correction to the president's direction. And there were many such strategies, but I'll just talk about one. And this one began long before 9/11. It began in the 1940s, after the Supreme Court decided, in a case called Korematsu versus United States, that it was constitutional for the United States to intern 110,000 people simply because they were of Japanese ancestry, the Japanese internment case. And when that case came down, Justice Jackson, Robert Jackson, one of the great justices, wrote a dissent in which he said, this is a dangerous decision. It will lie around like a loaded gun, ready to be picked up by the next president in the next crisis. And at the time, he was probably right. Justice Jackson was probably right, that that was a danger. But over time, he has been proven wrong. And why has he been proven wrong? He's been proven wrong because human rights organizations, civil society, civil liberties groups, including Japanese American organizations and the ACLU, did not accept the Supreme Court's decision in Korematsu versus the United States as the final word. They undertook a 40-year campaign to overturn Korematsu in the judgment of history and in the arena of public opinion. And they started in very small incremental ways. They sought to get back some of the property that people had lost when they were removed from the West Coast and interned. They sought to restore citizenship to many of the internees who had been essentially coerced into giving up their citizenship while they were interned. They then asked just for a commission of inquiry to look back at the decisions that were made. They conducted academic research. A guy named Peter Irons started looking into the underlying documents related to the internment and discovered that the Solicitor General of the United States had consciously kept from the Supreme Court information that would have undermined its case. They went back to the courts that had convicted Korematsu, the lower courts that had convicted Korematsu, and sought to overturn their convictions 40 years after the fact. And ultimately, they got Congress in 1984 in a piece of legislation signed by President Ronald Reagan to apologize for the internment and to pay $20,000 in reparations to the survivors. And that work over that period of time shifted the significance of Korematsu. So it went from a loaded weapon that could be picked up by the next president in a time of crisis, from a dangerous precedent, to an object lesson in what not to do in the next crisis, to an anti-precedent. And I remember I was standing in line at the Supreme Court to hear argument in the case of Rasul versus Bush, which was the first of the Guantanamo cases to go to the Supreme Court. And I was standing next to Steve Shapiro, who was my predecessor as the National Legal Director of the ACLU. And I said to him, how do you think this case is going to come out? And he said, well, I don't know how it's going to come out, but I have to believe that Korematsu is going to be at the back of the justices' minds. When, as in World War II, the administration comes in and says, defer blindly to us because this is a matter of national security. And it wasn't just at the back of the justices' minds, it was at the forefront of their minds because Fred Korematsu himself filed an amicus brief in that case, saying to the Supreme Court, don't make the same mistake again. And by the time the case went to the Supreme Court in Rasul versus Bush, 8 of the 9 sitting Supreme Court justices had said or written that Korematsu was wrongly decided. It hadn't been overturned because there hadn't been another instance of an internment, but 8 of the 9 justices said it was wrongly decided. So it had been overturned in the judgment of history. And that object lesson, I am convinced, played a critical role in the court's refusal to accept President Bush's arguments, quite similar to FDR's arguments in the Korematsu case, that you should defer blindly to us on matters of national security. So I think we're in a similar moment. Except while Trump has what Bush had in terms of a Republican Congress and a Republican majority court and many Republican majority state legislatures, he doesn't have the support of the people that President Bush had. He came to office, remember, losing the popular vote. He took office with the lowest approval ratings of any president who has taken office since we've measured these things. And his approval ratings have plummeted since that time, in the low 30s at this point. A Quinnipiac poll a couple weeks ago asked people, what's the first word that comes to mind when you think of President Trump? And then they tabulated the results. Number 1, the most common response, idiot. Number 2, the second most common response, incompetent. And it didn't get any better after that. That kind of position in a democratic society doesn't give you a tremendous authority to act. And so let me close by talking about the Trump travel ban, because I think this is an illustration of the point. The Trump travel ban should have worked. Why? Because it targeted foreigners in the name of our national security. Historically, that works. That's what we did during the Palmer raids. That's what we did in the run-up to the McCarthy era. That's what we did in the post-9/11 era. Historically, it works, because Americans care about their own rights, don't tend to care that much about the rights of others. But it didn't work this time. He enacted the thing on a Friday, and on that Saturday, January 28th, tens of thousands of Americans got up and went out to airports to protest, not for their own rights, but for the rights of others, for human rights, for the rights of refugees. It was incredible. It was entirely spontaneous. And if you think about it, it's not only incredible because people got up and spoke out against, on behalf of the rights of others, but they did so by going to airports. Now, I don't know about you, but the airport is the last place I would voluntarily go. Unless I have to fly somewhere, I am not going anywhere near an airport. It is a soul-crushing environment. And yet, tens of thousands of Americans spontaneously went to airports to protest on behalf of the rights of others. And it wasn't just people at the airports. Mike Hayden, who was Bush's, the head of the NSA and the CIA under Bush, a defender of the CIA's torture program, tweeted that weekend, "How about that? ACLU and I in same corner." Later, Dick Cheney criticized the measure as going too far. And finally, John Yoo, who wrote the torture memos, the infamous torture memos, as a Justice Department lawyer, wrote an op-ed in the New York Times entitled "Executive Power Run Amok." So, and they were joined by over 100 retired generals and admirals and national security officials who came out against the order. The presidents of most of the leading universities in this country, virtually all of Silicon Valley, all the major science institutions in the United States. And the courts responded by standing up to the president, by striking down the president's actions. First in the case that we filed in Brooklyn, then in a case that the Attorney General Washington filed in Seattle, and ultimately in the Ninth Circuit. After the Ninth Circuit ruled against the executive order, Trump tweeted, "We'll see you in court." This was a curious tweet, given that we had already seen him in court. He was in court, and moreover, he stole our, that was our brand, "We'll see you in court." He stole it from us. When he came out with a second executive order, we challenged it in Maryland, and another group challenged it in Hawaii, and both courts declared the ban unconstitutional. And let me read from the first page of the decision of the U.S. Court of Appeals for the Fourth Circuit, which just last week, in our case, affirmed that the order is unconstitutional. They say, "The question for this court, distilled to its essential form, is whether the Constitution, as the Supreme Court declared in Ex parte Milligan," which is a Civil War case, "remains, quote, a law for rulers and people equally in war and peace," close quote. And if so, whether it protects plaintiffs' rights to challenge an executive order that in text speaks with vague words of national security, but in context drips with religious intolerance, animus, and discrimination. Surely the Establishment Clause of the First Amendment yet stands as an untiring sentinel for the protection of one of our most cherished founding principles, that government shall not establish any religious orthodoxy or favor or disfavor one religion over another. Congress granted the president broad power to deny entry to aliens, but that power is not absolute. It cannot go unchecked, period. That is a tremendously powerful statement. But I think in understanding that statement and understanding that 10 judges of the U.S. Court of Appeals for the Fourth Circuit would sign on to a statement that strong against this president, it cannot be separated from the outpourings of support from people at the airports, from university presidents, from Silicon Valley, from national security officials against this order. And so I'll close with a quote from Learned Hand, one of the great judges, often called the greatest federal judge not to sit on the Supreme Court. He certainly had the greatest name of any judge not to sit on the Supreme Court. And Learned Hand was talking, this was from a speech he gave in 1944 in Central Park, speaking to 150,000 newly naturalized U.S. citizens. And he chose to talk to them about liberty. And this is what he said. He said, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. While it lies there, it needs no constitution, no law, no court to save it." Now this, like many great quotes, overstates the case, right? We need the Constitution, we need courts, we need law to remind us of the principles that we hold most dear, the basic human rights of liberty, equality, dignity, and privacy. But it recognizes a crucial truth, which is that those words on a page mean very little. And even with formal structures of government, checks and balances, separation of powers, they mean very little if liberty does not lie in the hearts of men and women. So what I'm so proud of about the ACLU and about human rights organizations and institutes like this one is that they are the institutions and organizations that nurture the liberty that lies in the hearts of men and women. And at the end of the day, that is where our salvation lies. Thank you very much.
Good evening. Now we are at the Q&A portion of the program. A couple of weeks ago, my son sent me a cartoon from the New Yorker in which a, obviously academic, presiding over a program with a panel next to him, announced to the audience, "We have now come to that portion of the program where we will entertain shorter speeches disguised as questions." We don't want that to happen tonight. David has said a lot.
We want longer speeches.
Yeah, no, he's done the line. We want questions, and there's a lot to ask questions. So if people have questions, want to line up at the mic, we would be happy to take your questions. So come one, come all. And while you're getting, oh, Brian, okay. I did forget to mention one very important item tonight, which is demonstrated on these posters. This next academic year, 2017-18, marks the 20th anniversary of the Posen Center. David Cole's talk is our opening event, and we will have many featured programs going on over the next year, and welcome you all back for the 2018 Kirschner Lecture. We are open to suggestions as to who can follow an act that's hard to follow, and we'd like to do that. I'd also like to encourage students to get up to the mic to ask questions. Brian.
Yeah, thank you, Susan, and thank you, David, for your terrific talk. I'm wondering if you might say a few words about the origins of the ACLU in the aftermath of World War I. This is the 100th anniversary of course, U.S. entry into the war, also the 100th anniversary of the Espionage Act of 1917, which, as you know, is still on the books and still being used to try people. So just a few thoughts on another centennial.
Yeah, so the ACLU is coming up on its 100th anniversary in 2020. It was founded in 1920. I think I just reviewed a book by a University of Chicago law professor, Laura Weinreb, on the origins of the concept of civil liberties in the United States, and it is coterminous with the ACLU. The concept of civil liberties did not exist in the United States or elsewhere until Roger Baldwin and others formed the ACLU and created it. And what I found most interesting about the history of the ACLU is that at its founding, it was a radically egalitarian, popular mobilization organization. It was deeply skeptical of courts. In fact, its first legal counsel, Morris Ernst, said, we can never expect justice from the courts. Now, that's not a message that you're going to hear from me, obviously, having just prevailed in the courts and very happy about that. But if you think back to that period of time, the only constitutional rights that the Supreme Court was recognizing at that time were the rights of corporations, of big business, not to be regulated in the interest of protecting workers and consumers. That's the only constitutional rights the court was recognizing. So the progressive movement saw the courts as the enemy, and the ACLU arose from that progressive movement. And it filed cases But it filed cases with no expectation of winning. They knew they would lose, but they felt like, well, if we lose, we will demonstrate the flaws and inconsistencies in the system and people will be mobilized. Then over time, they began to win some cases. They began to actually win some cases. And so they realized that they liked winning. And they began to, they shifted from a popular mobilization organization into an organization that was a legal organization focused on the courts, making nuanced arguments and developing a robust constitutional jurisprudence. And I think that, that's an appropriate transformation. It coexisted with the transformation of the court into a court that was more willing to protect the rights of ordinary folks, not just of corporations. But it sort of lost its popular mobilization side. And one of the things that we are now doing in response to the Trump moment is reverting back to the popular mobilization side. We've got 1.2 million new members. Many of them, the first question they have for us is, what can we do? And so we've launched something called peoplepower.org, which is an online application to facilitate and encourage offline activism by empowering local groups of people, informal groups across the country to engage in political campaigns, whether it be about the Affordable Care Act or whether it be about the rights of immigrants, by reaching out to their local representatives, to their federal representatives, but it is about mobilizing people. And I think that an effective civil liberties organization needs to be able to deploy resources in all forums, not just in the courts, not just in Congress, not just in the streets, but in all forums. And I'm happy to say that the ACLU is reviving that side of its original focus.
So I have two very short questions linked to Trump. First, Kathy Griffin has selfie with Trump head. Could it have some legal implications? Should I repeat?
No, I thought you said you had two questions.
Yeah. A second question is, could Trump destroy United States as we know it?
I don't know what the legal implications would be of Patty Griffin. Is it Patty Griffin or Kathy Griffin? Kathy Griffin's, yeah. So I can't speak to that. On Trump, whether Trump will change America as we know it, if we let him, he will. And I think probably the answer to that is yes. But
not change, destroy America as we know.
Oh, no. He will not destroy America as we know it, but I think he will change America as we know it. But I think the real question is, what will that change be? So one change might be that he will succeed in introducing all of the kinds of retrograde policies and proposals that he promised during the campaign. The other possibility is that because he has mobilize citizens in ways that I have never seen before in my time in this country, he will, in fact, cause us to change for the better. And I'm actually, if I were betting, I would bet on the second. I would bet that we will be a stronger country and that the defense of liberty and equality and dignity and respect for the rights of human beings will be stronger in the wake of Donald Trump than weaker.
Another sense of Make America Great Again.
Yeah, a different.
Hi. I have a three-part question, I guess. What is your opinion about the Federalist Society and states' rights? I kind of moved back to states' rights.
Yeah.
That's something I'm concerned about. And also, what do you think of the idea of the courts treating anti-communism, challenging anti-communism and anti-environmentalism based on the First Amendment? That it's like religious freedom. I think communism could be like a religion, as environmentalism could, but it should be a protected right, speech.
Well, let me take the now, and I've already forgot the first part of your question.
Federalist Society and states' rights.
Yeah. So the Federalist Society, look, I give a lot of credit to the Federalist Society. They are a very effective civil society organization. They have organized around a particular view of the Constitution, and they've done so with long-term commitment and strategic vision, and have been very effective in doing it. If you don't like what the Federalist Society is doing, join the American Constitution Society. It's doing the same thing on the other side, and that's the way. That's the way a democracy ought to work. I'm not a fan of many of the visions of the Constitution that the Federalist Society advances, but just as I'm not a fan of the individual right to bear arms, but I respect their commitment and I respect their strategic engagement, and I think that's the way constitutional dialogue and constitutional development works in a working democracy, through civil society, through citizens coming together around visions that they care about.
I just want to warn the people in line, I'm going to impose a bit of gender parity. We're going to take 2 more guys, then we'll take the next woman in line. So we'll just I want to even it up a bit.
I appreciate you mentioning peoplepower.org. Is that the right website?
Yep.
I think technology's done a lot to be disruptive in the corporate world. Is there, from the legal standpoint, a need or a way that you see might technology be able to be disruptive to what the current administration is trying to do, or impactful in what the courts may be hearing down the road, particularly in the case of like Citizens United and things of that nature?
Well, social media and technology are huge parts of the democratic process these days. I mean, that is, we have a very active social media account. We have over 1 million followers every day. We are using that platform to spread the message of the week or the message of the day, in the same way that Donald Trump used it to get elected. So and the same way that Barack Obama used it to get elected. It's part of the democratic dialogue, the democratic process, and it can be part of the checking process. So how was it that tens of thousands of Americans across the country, went out to airports on that Saturday? It was only because of social media. That never would have happened without the fact that people are linked in through a variety of networks, which give them, minute-to-minute actions that they can then join in the offline world. I think it's critical. What I like about People Power is that it's an online tool for offline activism. I think online activism is good, but it has its limits. Very important to get people together in the actual world rather than the virtual world. This gathering is more important, I think, than a tweet or a blog that I send out that this many people read, because of the connections made, the food that is eaten, the identity that develops through coming together as citizens in defense of the values that we care about. So technology is not the answer, but it's a part of the solution, as long as we don't limit ourselves to it.
Hi, David. My name is Gregory Joey Johnson, and actually David was my attorney many years ago in the U.S. Supreme Court flag burning case, so I'd like to publicly thank him. He did a good thing back then.
Thank you.
And his co-counsel was William Kunstler, the late great, and the two of them did a tremendous job, not just for myself, but for the people. But I also want to say, as a political defendant, we often have vigorous debate and exchanges with our attorneys in our cases. And I want to say, I want people to know that right now, even with our Supreme Court decision in Texas versus Johnson, 16 of us were arrested for burning the American flag outside the Republican National Convention in Cleveland as Donald Trump was being nominated and embodying all that ugly white supremacy and America first chauvinism and xenophobia. And there's still 14 people facing charges. And this was before Trump's tweet threat that flag burners should be jailed for a year or be stripped of their citizenship. What I wanted to pose to you is, it seems like tonight you're careful not to use the F word, fascism. And I would like for you to talk more about that, if you would, about the real danger of America going fascist and how Trump didn't go to the White House Correspondents' Dinner. He went to Harrisburg, Pennsylvania, to his base, as he calls it. And his white supremacists and neo-Nazis are marching ready to brawl in Berkeley, in Charlottesville, Virginia, in New York City. And do you think this country can't go fascist? Because I think it can, whether or not Trump's impeached or not. Yeah.
So here's what I'd say. First of all, the fact that you were arrested in 1984 at the Republican National Convention for burning a flag, and in 2008, 2016,
Yeah.
2016.
Do the math.
Yeah, sorry about that. Is a testament to your commitment. As to whether the United States is going to go fascist, I would say no. I have a tremendous faith in the American people, and I have seen that faith, proven by the kinds of engagements that we have seen since 9/11. I mean, we've seen them since 9/11, but we've really seen it since the election of Donald Trump. And as I said, a number of times from the podium, that will be our salvation. So no, I have very firm faith in the power of the basic rights and values that define us as a nation, that are in our Bill of Rights, which were then adopted and expanded and extended in the Universal Declaration of Human Rights. And no, we don't live up to them perfectly. No country does. But I do believe that there is a reservoir of commitment to those values. And if we stand up for them, we will preserve this democracy. And I'm confident that we will.
Thank you. I want to say,
Thank you.
without agreeing with the whole thing about the democratic values and tradition, I do agree that the people, that we in our millions, but people got to get their asses out in the street and do it. That's how we got to stop this regime.
Thank you.
Hi, I'm an undergrad at the University of Chicago, but I wanted to ask what the ACLU has done and is doing with regards to the current administration's promotion of maximum sentencing for drug charges that disproportionately affect minorities.
Yeah, great question. Very disturbing. I wrote a piece for the New York Review last week or so about Jeff Sessions, who introduced the policy that requires federal prosecutors to charge drug defendants with the maximum possible sentence, regardless of the circumstances. Reversing the policy of Eric Holder, which was to engage in smart charging and to reserve the harshest charges for the worst offenders, in which I argued that Sessions was actually more dangerous than Trump, because while Trump has been mired in scandal and largely ineffectual and can't even spell Covfeff correctly, Jeff Sessions has been putting these things into place. But here's what I'd say about criminal justice. Jeff Sessions has a limited authority over criminal justice. Why? Because he can tell federal prosecutors what to do, but federal prosecution is about 10% of the criminal justice system. The 90% of the criminal justice system is enforced by state DAs who do not have to listen to Jeff Sessions. And what we have seen, we have a $50 million multi-year campaign to reduce mass incarceration through state-by-state advocacy, litigation, and communications. And what we have seen is that there is, notwithstanding Jeff Sessions, notwithstanding Donald Trump, there is a bipartisan consensus that our criminal justice system is out of whack, that mass incarceration is unacceptable, and that we need to reduce the harshness of our criminal justice system. So we are in collaboration with the Koch brothers, Right on Crime, the Tea Party's Freedom Works, the Grover Norquist's Federation for Tax Reform, ALEC, which is an organization that pushes various conservative reforms at the state legislative level, us, the Center for American Progress, George Soros. We are all together in a coalition to reduce the harshness of the criminal justice system, and that will continue regardless of Jeff Sessions and Donald Trump. And we will continue fighting for that because I think it's the single greatest challenge, civil rights challenge, that this country faces.
And Cook County elected Kim Fox. So we have somebody who's sympathetic, at least, to be bringing local advocacy on this issue, too. We can take one more question, and then Claudia Flores from the International Human Rights Clinic at the law school is going to come up and close out the program.
Hi, I'm Eric. I'm a second year at the med school. I've always been confused about the 10th Amendment, and I was just wondering if you could kind of explain what, if anything, is unique about the sanctuary cities and why, in a future Democratic administration, states might use the same argument to not enforce environmental regulations or something of that nature, or if immigration is just sort of a unique federal-state division.
Yeah.
Great question. So the 10th Amendment reserves powers not given to the federal government to the states. And it's fairly open-ended provision, but it has been interpreted in a variety of ways over history. But the current interpretation, the one that has been guided the court for the last 15, 20 years or so, says that what the 10th Amendment stands for is that the federal government cannot commandeer state law enforcement officials, executive officials or legislative officials, into enforcing federal law. Congress can pass federal laws, but then the federal government has to enforce those federal laws. States pass state laws and they enforce state laws, but they have the choice as to whether they want to enforce federal laws or not. And yes, this is sometimes used by Republican states to resist democratic federal initiatives that conservatives and Republicans don't like. In this instance, it's being used by democratic cities and states, liberal urban areas in particular, to resist a conservative federal prerogative. To me, I think it can be used either way. I'm certainly happy that we have Democratic state attorneys general, like the state attorney general of Washington, who brought the case challenging the first travel ban, and the state attorney general in Hawaii, who brought the case challenging the second travel ban, to stand up to the president. It's another institution that provides a way of checking the federal government. And particularly when the federal government, all three branches of the federal government are controlled by one party, the importance of having alternative fora that can act as a check is critically important. So, in my book, Engines of Liberty, I talk about, how the gay rights movement got marriage equality to where it was by 2015, and how the NRA got the individual right to bear arms recognized by 2008. And the one thing that's common between those two movements is that they used the states as laboratories for experiment. They advanced their visions first in states, using state law arguments, limiting them to state law arguments, going to the states that would be most hospitable to their views, and then they extended out from the initial wins to one state, another state, until they had enough momentum that the claim could essentially jump the tracks and go into the federal courts. And so I think from the standpoint of an advocate, it's, what is needed, what you need are forums where you can be heard. Sometimes those forums are the streets, sometimes, but oftentimes they are, slightly more formal forums like state legislative bodies or town councils or the Congress of the United States or a state court or a federal agency, right? These are all different forums, venues in which we can make our arguments for our visions of the Constitution. And so I've come around from a view, I think a sort of mainstream view when I was coming up in law school, was that states' rights is just always something that the conservatives used to push back against liberal reform, because we thought of it, as a tool to fight desegregation. That's what it was. But it is actually more than that. It can be a tool for both sides, and it is an integral part of the checks and balances of our democratic society. And you see that with the sanctuary cities movement.
Okay. Hello, everyone. As Susan said, I'm on the clinical faculty at the law school and director of the International Human Rights Clinic. I'm also a former ACLU lawyer. I began my career at the national office, and I think this is a saying that once an ACLU lawyer, always an ACLU lawyer. I credit the ACLU with my understanding of what lawyers can do in advocating from a holistic perspective, using the kind of community organizing, local organizing that David was talking about, and combining that with impact litigation and some policy goals. And while I'm primarily up here to thank David, I will say that I'm still smarting from the knowledge that if I had just stayed at the ACLU, I could have been in Vogue one day, rather than coming to the University of Chicago. It'll take me a little while to recover from that. I will say, both as someone who does human rights work and is invested in the recent developments in our country, that I am very comforted to know that the ACLU is now proceeding under David's guidance, spending a lot of time now with students. Many of you, the students here that are here, this is the first time in your adult lives that you are seeing fundamental provisions of our Constitution at risk of somewhat quick and chaotic erosion. And perhaps it's also the first time that you have the sobering realization that the US, like many other countries in the global community, is not immune to the impact of political power on the legal rights of individuals. And having spent the second half of my career abroad working in other countries, I guess I want to take a moment to really be thankful that we have made this happen, as David pointed out, but we have a robust organization that is powerful, that has national reach, that is ensuring that the kind of damage that the current political leadership might do is going to make sure to contain that damage. And that is something to really keep in mind and be thankful for. And just lastly, in thinking about human rights and international human rights, unsurprisingly, the ACLU has been and continues to be at the forefront of recognizing the importance of protecting our domestic rights through the enforcement of international human rights law. In fact, the National Office has a program dedicated to this very goal. And so enforcement of these principles that the ACLU is involved in, and principles in which the US played a significant role, as we all know, in crafting, will help us now provide an enduring backdrop and an interpretive lens to understanding our constitutional rights as fundamental concepts that promote life, human dignity, and autonomy. So please join me in thanking David for a really inspiring lecture.